So if you've been here before, welcome back. If you haven't been here before, hello, my name is Tats. I am a full-time paralegal. I hold a degree in criminology, a master's degree in legal studies, and I teach law at the university level. I am not, nor will I ever be, an attorney, so I cannot give you legal advice. Anything I say on my lives, my content, or my comments is my opinion, and my opinion only. If you need the services of an attorney, please seek one out in your area. If you need to get a hold of me for any reason, please do not send me a DM on TikTok. I try to stay out of those as much as I can. There is a link in my bio that says send a question or a case to Tats. Please use that link. That will put your question or your case. Thank you so much, Andrea. I appreciate that. Right onto my spreadsheet. As you guys know, I am the queen of spreadsheets. And that will allow me to get back to you a lot quicker than if you're lost in my DMs. Hey, NEM, nice to see you. All right, so we're going to do this a little bit different. Usually I do stop and read the chat. So tonight I am going to have places where I'll stop and ask for your questions, but I'm going to be going through the slideshow pretty quickly. Not so quickly that hopefully you don't understand it. And once Jimmers gets in here, he'll be able to pin your, hey, Allie, nice to see you. Thank you for that heart on my head. He'll be able to pin your questions for me so I see them more clearly. But I just wanted to let you know that. I know that the chat moves quickly. If you wouldn't mind just tapping the screen, that gets us out to the FYP, gets more like-minded and not like-minded people in here. We do welcome all opinions in this room as long as they are respectfully given. If you're disrespectful to anyone in the chat or myself, Jimmers will, once he's in here, mute and boot you. We don't like to do that, but we will do that. Deba, thank you for that heart on my head, and those Go Populars, appreciate it. I got your celebrity doppelganger, Hannah Banana. Who's that? Selena, thank you for that heart me. Oh, I'm curious. Who's my, oh, maybe I don't want to know who the celebrity doppelganger is. All right, are we ready? Let's start. So it's U.S.A. versus Mangione. Again, this is the federal case, right? The New York State case and the Pennsylvania State case, those are different. We can go through those criminal charges just like we go through these tonight at another time. But I just want to be clear, tonight we're talking only about what is left in the federal case. So complaint count 1, which is like an indictment, from at least on or about November 24th, 2024 to in or about December 4th, 2024 in the Southern District of New York and elsewhere, Luigi Nicholas Mangione, the defendant, traveled in interstate commerce with the intent to kill, injure, harass, intimidate, and place under surveillance with the intent to kill, injure, harass, and intimidate another person, and in the course of and as a result of such travel engaged in conduct that placed that person in reasonable fear of death and serious bodily injury to that person, and in the course of engaging in such conduct caused the death of that person, to wit, Mangione traveled from from Georgia to New York, for the purpose of stalking and killing Brian Thompson. And while in New York, Mangione stalked and then shot and killed Thompson in the vicinity of West 54th Street and 6th Avenue. That is count 1. There is a reason I'm reading these whole things out loud, and you guys will understand that in just a minute. Okay, count 2. From at least on or about November 24th to on or about December 4th in the Southern District of New York and elsewhere, Luigi Nicholas Mangione, the defendant, with the intent to kill, injure, harass, intimidate, and place under surveillance with intent to kill, injure, harass, and intimidate another person, used an electronic communication service and electronic communication systems of interstate commerce and a facility of interstate or foreign commerce to engage in a course of conduct that placed that person in a reasonable fear of the death of serious bodily injury to that person, and in the course of engaging in such conduct caused the death of that person, to wit, Mangione used a cell phone, interstate wires, interstate highways, and the internet to plan and carry out the stalking, shooting, killing of Brian Thompson in the vicinity of West 54th Street and 6th Avenue in Manhattan. All right, so those are the 2 counts that are left. That's count 1, count 2 of the original indictment. So let's talk about what the stalking charge is. I know that's probably hard for you guys to read, so I'm going to read it. Let's see, right there. Okay, so this is 18 U.S. Code Section 2261A, stalking. Whoever travels in interstate or foreign commerce or is present within the special maritime and territorial jurisdiction of the United States, or enters or leaves Indian country with the intent to kill, injure, harass, intimidate, or place under surveillance with the intent to kill, injure, harass, or intimidate another person, and in the course of or as a result of such travel, or presence engages in conduct that A, places that person in a reasonable fear of death or serious bodily injury to that person, an immediate family member, a spouse or an intimate partner of the person, or the pet, service animal, or emotional support animal or horse of that person, or B, causes, attempts to cause, or would reasonably be expected to cause substantial emotional distress to a person described in clause 1, 2, or 3 of subparagraph A. So that's what we just read. 2, with the intent to kill, injure, harass, intimidate, or place under surveillance with intent to kill, injure, harass, or intimidate another person, uses the mail, any interactive computer service or electronic communication service or electronic communication system of interstate commerce or any other facility of interstate or foreign commerce to engage in a course of conduct that places a person in reasonable fear of death or serious bodily injury to a person, a pet, service animal, an emotional support animal, or a horse as described in clause 1, 2, 3, or 4 of paragraph 1A. That's what we read above. Or B, causes, attempts to cause, or would reasonably expected to cause substantial emotional distress to a person described in clause 1, 2, 3, or paragraph 3 of paragraph 1A. Shall be punished as provided in section 2261B or section 2261 capital B as the case may be. Okay, so the reason I'm reading that out loud to you, 1, I know it's hard to read. 2, does that not sound exactly like what they charged him in the indictment or in the complaint? There's a reason for that, right? They have to bring the charges as they are written. And that's what we're going to go through tonight. So I'm going to break down each one of these elements, and then we're going to go and try to look at the evidence that we know of. Remember, we don't have all the evidence, but we're going to look at the evidence that we know of to see if we agree, disagree. Hey, Jules, nice to see you. Nolly, hello. Nice, thank you for that heart on my head, dear. We're gonna try to figure out if and where the holes for each one are. So the holes for the government and the holes for Luigi. DP Pink, thank you for that follow. You're not that late, Golden Brown. We just started. I just came in. What are you talking about? Beautiful life. This is a breakdown of the stalking charges in Luigi Mangione's federal case. Smoke, did I make you a mod? I thought you were a mod. I don't see. Okay. Thank you guys. 11,000 taps so far. Appreciate that. I don't see Jimmers in here yet, but he'll get here soon. He'll be able to pin your stuff. All right. Elemental breakdown. Count 1. 18 U.S.C. 2261A1. Interstate travel. In plain English, what's that mean? He crossed state lines. Government evidence. He took a bus from Georgia to New York City. He had a surveillance timeline and hostel registration. So we've seen that picture of him at the hostel, right? But we don't know everything in the NYPD timeline, data, evidence, or other physical evidence. So keep that in mind, right? They might have more stuff that leads to their theory than we know about. So I want you guys to keep an open mind. Tonight we're just talking about what they have to prove beyond a reasonable doubt. And then I'm also going to talk about possible rebuttal from Luigi's team. And on this first count, possible rebuttal is the identity challenge, which we've talked about ad nauseum in here. Argue travel was for another purpose. Attack the timeline for any gaps. So, it's not illegal to go from Georgia to New York City if you just want to go see the city, right? It's not illegal to grab a bus and ride up the coast. So they have to prove beyond a reasonable doubt that at the time he got on the bus from Georgia to New York City, that was specifically intended to stalk and injure, put at fear, or kill Brian Thompson. All right, that's element 1. Element 2, intent at the time of travel. So I just kind of went over this. He crossed state lines already intending to kill, harass, intimidate, or surveil the victim. The intent must exist before or during travel. So if he decided on the bus ride there that he was going to do it, or he was going to allegedly do it, that counts as well. But he has to either be decide before he gets on the bus or on the bus on his way to New York City that he was going to do this. The government theory, the notebook entries referencing investor conference, alleged planning, false ID, counter surveillance behavior, and waiting near the hotel. We saw that as well. And then the defense could argue the intent was formed later. Notebook is ambiguous. Political ideology does not equate intent to stalk a specific person. Please remember that, specific person. Travel for general purpose and not targeted stalking. So these are possible things. I want to be really clear. You guys know I am not on Luigi's defense team, but this is just me analyzing how they could possibly defend this, right? Cancer, hello, darlings. Nice to see you. Violetta, thank you for that, Rose. Cancer, I hope you're doing well. All right. That is the second part. The third part, the course of conduct. There must be a pattern of behavior, not just a single spontaneous act. What does that mean? The actual shooting is not a pattern of behavior. That is one act. So there has to be some sort of pattern of behavior leading up to the shooting. So the government's theory, arrival at New York City on November 24th, well ahead of when that shooting took place. Surveillance of the hotel. Returning on December 4th, waiting outside. Remember, we saw the shooter waiting across the street, using the phone and allegedly tracking Brian Thompson. The defense counter and possible rebuttal argue this was a single premeditated homicide, not stalking, not repeated communication with the victim, no harassment history. And again, we don't know what data they have. We don't know what came from the cell phone that they allegedly found. We don't know if there was any direct contact with Brian Thompson from the shooter, but that would go a long way to saying, thank you, Cancer, appreciate that. That would go a long way of saying that he was stalking Brian Thompson, right? And remember, in those counts, they specifically said Brian Thompson. I want you guys to remember that because I'm going to come back to that. All right. Fourth one, and this is the one that I hear about from you guys the most. Reasonable fear or substantial emotional distress. The conduct of the defendant must have placed the victim in reasonable fear of death or caused substantial emotional distress. The prosecution can argue surveillance plus confrontation and the shooting satisfies this. They may argue fear is inferred from circumstance. What does that mean? I'm going to get to that when I play you part of the video and get your opinion on that. So what that means is just the fact that he got shot, they could infer from that, and this is the government theory, right? Infer from that he was in reasonable fear of death or caused substantial or emotional distress. Okay, the defense is this is possible rebuttal for Luigi's team. Ambush argument, victim had no prior awareness and therefore no fear. Statute is designed for harassment cases, not surprise shootings. Hey, Mangione Nation. Nice to see you. Thank you for those gifts. I appreciate you. All right. And then the last one, death resulted in penalty enhancement. So as I said, if this stalking if he is convicted of stalking and they can prove that it ended in death, then there is that penalty enhancement of life without parole. If death results, enhanced penalties apply. Shooting caused the death. The defense may argue stalking elements fail, making enhancement irrelevant. So in other words, he's either found guilty beyond a reasonable doubt of those first four elements, or the death enhancement has nothing to do with it, right? So they have to meet beyond a reasonable doubt on all five of these. I would argue four of them in order to convict him of the stalking. Then they have to prove that the stalking ended in death in order to get that enhanced penalty. All right? So I'm going to pause right there. Hey, Stacy, nice to see you. Hi, I never saw a lawyer wrote an assassin enough presumption of innocence when he wrote pages. Boreal, I may have to have you, in the words of Judge Bev, ask that a different way. Any specific questions before I go on to count two? It's going to be a lot of same as count one, but I think it's important to go over it before I give you the evidence and ask you what your opinion is. Amanda, hello. It's 136 people in here, 141, sorry. If you guys would all tap the screen, that would be, oh, Nolly D, thank you. You don't have to do that, but I appreciate it. Are we not to see you? You can't see me, Mindy? Yeah, I'm at the bottom of the screen. You can't see me? Hang on, let me see if I can see. Nope, I can't. You can't see me? That's all right. You can hear me, right? You don't need to see me for this. That's weird. Jackie, you can see me? Okay. Mindy, maybe scroll out and come back in. Everybody else can see me but Mindy. I'm not hiding from you, Mindy, I promise. Amber, how are you? Nice to see you. Crime Bear, thank you for that heart on my head. Amber, thank you for that heart on my head. Mindy, just try scrolling out and coming back in. Sometimes that resets it. It's probably a glitch. Yeah. All right. Let's go on to count 2. First Starbucks break. Alicia, you can see me. How are you, Amber? Karen, thank you for that follow. I had to do that because it froze at one point. Okay. Black Cat, you know the drill then. You see me? All right. It was you, Mindy. Okay. Well, now you can see me. Hello, Mindy. Nice to see you. All right, let's go on to count 2. All right. First element of count 2 is the use of interstate facility. He used the internet, phone, mail, wires, or other interstate systems. The government theory is that the cell phone that was found near the hotel, the alleged internet use, interstate highways, bus travel, and possible digital searches. Again, we don't know what we don't know with the data, right, because of that gag order. Possible defense, possible rebuttal. Merely possessing a phone isn't stalking. No proof of threatening communications. Usage must connect to stalking conduct. Again, we don't know if he threatened Brian Thompson specifically, if any text messages, emails, anonymous messages that maybe they downloaded from his MacBook. Ooh, sorry, my cat. My cat just... All right, she wants up. You guys know... Sometimes she makes an appearance. All right, Zazzy, say hello to everyone. Everyone say hello to Zazzy. We don't know what was on that phone. We don't know what's on his MacBook. To me, when he was arrested at McDonald's, it looked like he was on his computer, and she's gone. It looked like he was on his computer, possibly either researching stuff or communicating with somebody, but we don't know what we don't know. Even if only guilty on one stalking count, still good possibility of life without parole. I believe so. Red Gypsy, yes. Oh, they're saying hi to you, Zazzy, and she's just sitting down here staring at me. How are you, Cousin Jody? Thank you for sharing this out. Okay, that's the first part of, or the first element of count 2. Second element of count 2 is intent. He used those facilities intending to kill, harass, intimidate, or surveil the victim. Government says phone planning, notebook, Fed's letter, you guys remember that letter, alleged research of the conference, and digital trail. Possible rebuttal, argue intent, speculative. Digital activity is not proven to target the victim, Brian Thompson. Generalized anger does not equate targeted stalking. So these counts are very specific to the victim. Right. Just generalized anger towards a system or a company is not specific enough. Hey, True Crimes Live. Oh, hey, Greg. Nice to see you. All right. 3, the course of conduct. This is the same as count 1. Pattern of conduct via electronic means. Travel coordination, planning, digital searches, alleged tracking behavior. And the possible rebuttal is no repeated messages, no communication to the victim. Isolated planning does not equate stalking in a course of conduct. So what does that mean? That means planning a trip to New York does not mean you're going there to stalk somebody. There has to be something else that points directly to the victim. Cherokee, hello. Greg and Cherokee, thank you for those hearts on my head. Hey, Tennessee Kid, nice to see you. Don't forget to add me. You know what? Hang on one second, because I could use you right about now. Oh, I can't do it from here. Oh, I had to do it beforehand, Greg. I will add you after I'm done. Sorry about that. I could use you today, too. It figures, right? But, yeah, remind me. Chris, how are you? Nice to see you. Okay. So, course of conduct, again, just like in count 1, you have to have not just one thing. It's not just the shooting. There has to be a course of conduct, a pattern that happened before the actual shooting happened. All right. Elemental breakdown. Number 4, reasonable fear or substantial emotional distress. This is the big one for me. Conduct must place the victim in fear or cause distress. Government will likely merge this count with one theory of surveillance. Thank you, Cherokee. Appreciate that. Hang on. Sorry. Thank you, Shelley. And Life is But a Meme. Thank you for those gifts. I appreciate that. Reasonable fear or substantial emotional distress. Conduct must place, so the conduct from number 3 above, must place the victim in fear or cause distress. The government will likely merge this with count 1 theory of surveillance plus confrontation. So we, like I said, we heard about this in count 1. plus the shooting satisfies this, may argue fear is inferred from the circumstance. What does that mean? I'm actually going to get into that a little bit deeper when I show you the video of the crime again. We're only going to watch the first 10 seconds, but it is disturbing. So let me just give you that heads up that if that kind of thing disturbs you, before I play it, I'll tell you again. And then possible rebuttal, same ambush defense problem, no evidence the victim was aware prior to the shooting. If the victim had no prior awareness, he would have no fear. The statute is designed for harassment cases, not surprise shootings. So again, same thing. All right, couple things I want to talk about that might be different from how we use them in regular conversation versus how they are defined in legal terms. Before I go on to this, hey sexy twerker, yeah, you only missed a little bit. Jolie wrote pages. Oh, now I get what you're saying, Boreal. Yeah. Okay, Chris Joy has watched my live for 200 minutes. That means you get a free therapy session. Before we move on to legal definitions, are there any questions on the indictment or the elements that have to be proven beyond a reasonable doubt before I move on? Thank you, Greg. I appreciate that. Anyone, 20,000 taps. Wow, you guys, now you're going to need carpal tunnel surgery. Okay, no questions before I move on? All right. Legal definitions. Intent. So this is really important. The intent in these statutes are specific intent. And it's required. It cannot be recklessness or negligence. Okay? Intent, specific intent, is a conscious, objective, or deliberate purpose to achieve a particular result. For this subsection, the government has to prove the defendant acted with the purpose to kill, injure, harass, intimidate, or place under surveillance. The intent must exist at the time of the conduct, and for count 1, at the time of the interstate travel. So for count 1, if his intent when he got on that bus or while he was on that bus from Georgia to New York was not to come to New York City to intimidate, kill, injure, harass, or place under surveillance Brian Thompson, then count 1 fails. And it can't just be recklessness or negligence. It has to be specific intent. All right. Course of conduct. A pattern of behavior composed of 2 or more acts evidencing continuity or purpose. Courts interpret this to require more than a single spontaneous act, or the shooting. The acts do not have to be identical, but they have to demonstrate a related series of actions directed at that person. So that it requires continuity, not just one single explosive act. So we're talking about it's not illegal to ride a bus to New York City, right? But it can be a course of conduct if you get on the bus thinking you're going to New York City to kill somebody. It's not illegal to rent a hostel room in New York City, but it can be a course of conduct if you got on the bus thinking, or on the bus you changed your mind and decided that when you get to New York City you're going to kill, injure, harass, or surveil somebody. So that is course of conduct. It can't be one act. It has to be more than one, and it can't just be the actual shooting. It has to be a course of conduct. Are we good? Give me a thumbs up if I lost you guys, just let me know. Hey Jen Pie, nice to see you. All right, this is the big one. Reasonable fear. Fear that an ordinary, reasonable person in the victim's position would experience under the same circumstances. It's an objective standard. The jury evaluates whether the fear of death or serious bodily injury would be reasonable, not merely whether the victim subjectively felt afraid. So objective standard is determined by a jury applying the reasonable person test. This is where it gets a little bit technical, right? So what would a reasonable person do? And why are those words used so much in our legal system? I would argue that they are used so much because of the vagueness. Why? Because a reasonable person, let's say you're in the medical field, right? And it's not reasonable for you to freak out if you cut your finger, right? But somebody like me, well, that's bad because I have medical experience too. But let's say somebody like a librarian cuts their finger and they freak out. That is reasonable for them, right? Where it wouldn't be reasonable for an ER doctor. Does that make sense? So the reasonable standard, the reasonable fear, the reasonable person, it's objective and subjective at the same time, right? If it's objective by the jury applying a reasonable person test. So it's not really correct in trials to ask the jury to put themselves in that position. But at the same time, jurors are allowed to bring real life experiences into the jury room to make conclusions on not reasonable doubt, on common sense. So is it common sense that if you turn around and someone's shooting at you, you are in fear? I think that's common sense, right? Is it common sense to walk around New York City just thinking you're going to be shot? No. Do you see what I mean? So the reasonable fear has to be objective and determined by the jury. So that's a question for the jury. Does intent have to be against Brian Thompson? Yes, it does. Nope, we're going to get to that, sexy twerker. Don't worry, you're here in time. We read the indictment before you got here, and he is specifically listed as the victim. So yes, it's going to have to be specific to Brian Thompson. All right, substantial emotional distress, significant mental suffering or anguish that may but does not have to require medical or psychological evidence. Courts interpret this as distress that goes beyond trivial upset or minor anxiety and rises to a serious level of emotional impact. Must be substantial, not minor discomfort or temporary upset. Again, that depends on the person, right? So if you have somebody who has an anxiety condition, maybe walking around New York City would raise their fear level, right? But that fear level would be raised by the anxiety, not necessarily by a course of conduct by a defendant intending to injure, kill, or harass that person. Does that make sense? Am I good? Pierogies, you made it 35 minutes in, but that's semi-early. We're only halfway done. Sexy twerker, you have mod privileges. I just realized that. Makes sense. Okay. And then next one, last one. Use of an interstate facility. The use of any instrumentality or channel of interstate commerce, including telephones, cell phones, the internet, email, interstate highways, even mail. Does anyone use mail anymore? Or wire communications. The use must be connected to the course of conduct and cannot be incidental. It must further or facilitate the stalking behavior. So this is a very broad definition, right? But it has to be in furtherance of the stalking, not merely incidental. What does that mean? He gets on a bus and he rides the bus to New York City. But if it's not in furtherance of something he already planned, then it's incidental, right? He rents that hostel room. But if it's not in furtherance of planning to kill Brian Thompson, then it's not in furtherance. That's what that means. Yeah, thanks, sexy twerker. I know you might be at work, so if you can't do that, that's a problem. All right, so then I pulled these. I don't know if you guys are interested in these. We can skip them if you want to, but Red Gypsy. Brian Thompson was already receiving threats and had security. So how is Luigi Mangione culpable when that was Brian Thompson's baseline? Good question. So even though he was in fear, Red Gypsy, that fear, in order for Luigi to be convicted, has to come from Luigi's course of conduct. Not just because he was getting random threats. If he was in fear of random threats that they can't prove came from Luigi, right? If it was somebody else doing it, then it's not out of the course of conduct that Luigi allegedly did. Does that make sense? You're cooking dinner. I'll be over after I'm done. Yeah, good question. But did that make sense, Red Gypsy? I mean, he could have been in fear from the SEO investigation that was going on. He could have been in fear of testifying at Congress the next week, but that wouldn't have anything to do with Luigi, right? His fear has to come from Luigi's alleged course of conduct, specifically towards him. Hooked on a feeling. Hello, nice to see you. Okay, so these are called pattern jury instructions. What are pattern jury instructions? They're a paralegal's best friend when they're prepping for trial. Pierogies, thank you so much for those gifts. I appreciate that. Exactly what I was wondering. KFA can point out it wasn't specific to the LM. Right. As long as they don't have that in data. Remember, we don't know what we don't know, right? They could have something in his laptop. They could have something in that cell phone that ties directly to messages to Brian Thompson. And if so, then those counts are going to be much easier to prove. Pattern jury instructions are instructions like in a book, literally a book of instructions that you go to what the charges are in a criminal case or a civil case, what the allegations are in a complaint. And there's a bunch of pattern jury instructions. And you take those instructions and you say this one applies and this one does not, and that one applies and that one does not. You take all those instructions, you put them together with the other side, whether it's the government or the defendant or the plaintiff, and you put them together and you give them to the judge, and the judge decides, I'm going to do this one, I'm not going to do that one. I'm going to do this one, I'm not going to do that one. In addition to pattern jury instructions, there are instructions that can be brought in through case law, through statutes, specific statutes, although this is kind of where it comes from, and appellate work, so from appeals decisions and things like that. Hello from Brooksville, Florida. I'm sure it's much warmer where you are than where I am. Hello, it's nice to see you, Nicole. Must be so hard to educate a jury. Pierogies, that's an interesting way to put it. It's not difficult. It just takes some practice, I guess, is what I'm trying to say. Because you want to talk to them in a way that they're going to understand it. And obviously you get 12, 14, 16 jurors, depending on how many alternates you have. They all have different educational backgrounds. They all have different ways of reading and ways of learning. So yeah, you're trying to reach as many of them on as many levels as you can. Hey Stan, how are you doing? Hey Polly, how are you doing? Polly, I need to talk to you offline. Let's see, sexy twerker. Brian Thompson didn't bother to get security even when other UHC heads did. Was he really in fear? I thought his security detail was inside the hotel, sexy twerker. But they weren't with him. I hear what you're saying. Luigi's family is in the healthcare industry. It's reasonable that he was following healthcare news. Violetta Mezzanotte, hold on to that because we're going to look at a couple of journal entries tonight. How are you, Stan? I hope your knee's doing well. Okay, Polly. We'll connect offline then. All right. So this possible jury instruction, I'm not going to read it to you. It's very similar to the actual statute. And the same with the using interstate facility. And again, this will be posted over on YouTube. So, and you guys know whenever you want something that I have, just send me a message and I'm happy to share it with you. I do not gatekeep. Daytona Beach, Florida. Florida gang. Daytona Beach. I shouldn't say anything. In 2 weeks, I'm going to be in the Bahamas. So I'm not even going to say anything. You're good, knee bad? Oh, sorry, Stan. Well, I'm glad you're good. I hope your knee gets better soon. Everyone, Alicia, everyone who wanted Brian Thompson gone was there with security detail of some sort. All right. Are you talking about the other CEOs? Violetta, thank you for those gifts. You guys, thank you for the gifts and the hearts on my head. I appreciate it. The 31,000 taps, I really appreciate that. Can you come with me? I'm going with a party of 3. We're already booked up, Stan, but maybe next time. Okay, Alicia, I got you. Okay, so if you guys wouldn't mind tapping the screen just like you're doing, thank you for the gifts. If you can send a heart on my head, that is appreciated. If you can't, just please tap the screen. That's great. Oh, another one. Well, Sand Dollar, I would assume that you're at the beach. That just makes sense. All right. Definitions for the jury. So this is where, I forget who said it, but educating the jury. Specific intent means the defendant acted knowingly and purposefully with a conscious objective to achieve a particular result. It's not sufficient that the defendant acted recklessly or negligently. The government has to prove the defendant acted with specific intent. Again, he didn't just get to New York and decide, oh my goodness, that CEO's down the street, I'm going to go unalive him. Right? It had to be intent when he got on the bus or when he was on the bus on his way to New York City. Course of conduct means pattern of behavior composed of 2 or more acts evidencing continuity of purpose. A single isolated act standing alone is not sufficient. We went over that already, so I'm not going to beat you guys with a dead horse or a dead definition. Reasonable fear means fear that a reasonable person is in the same position would experience under the same circumstances. Again, this test is objective, and it's going to be up to the jury whether or not the reasonable fear or the reasonable person standard was met. And then substantial emotional distress means significant mental suffering or anguish that's more than trivial. Again, not an anxiety attack, right? More or minor, or minor upset. It need not be accompanied by physical injury or medical treatment. That's big, right? You don't have to have a physical injury in order to reach substantial emotional distress. There are some states where if you don't have a physical injury, you cannot bring, I'm thinking civilly now, you cannot bring a claim for substantial emotional distress if you have no physical injury. Interstate commerce, facility of interstate commerce. A facility of interstate commerce includes any means of instrumentality used to conduct business or communications across state lines, including telephones, the internet, mail, and interstate highways. So mail, I mean, think the Unabomber, Ted Kaczynski. Remember what he did? He used to mail his manifestos into the newspapers. All right. Let's go over this really quickly because I think this is what you guys were talking about earlier. Let's talk about leverage analysis. Oops. Sorry. Way too much. There we go. All right. So here's our issues on the left-hand side. Interstate travel strong because he took a bus from Georgia to New York. Limited leverage for the defense. They could challenge the identity linkage or argue his travel had alternative purposes, but this is likely the cleanest element of the government. Specific intent at time of travel. Moderate strength because of the notebook entries referencing timing of the investor conference. Alleged planning, false ID, counter surveillance behavior suggested a pre-formed intent. Yeah, sexy twerker, I'm going to show those. If Luigi Mangione lived in New York, would any of this need to apply? Good question, LLN. They would still have to show a course of conduct, and that interstate travel count probably would not have applied because he wouldn't have crossed state lines. But they could still, get him for using the cell phone or using Venmo, PayPal, the telephone, mail. I'm trying to think. That's a good question, LLN. I think one of the charges would still apply. Do they typically charge for use of an interstate facility in murder cases? In federal case, yes, Progies, and let me tell you why. In federal cases, to bring a murder charge, you have to have a predicate charge of violence, right? Or a predicate crime of violence. And in this case, they were using these stalking charges as the predicate crime of violence. But we know from that motion to dismiss that Judge Garnett granted that she did not rule or she did not agree that these charges were predicate crimes of violence. Now, we can dig into that a little bit deeper. But basically what her ruling said is because these crimes can be violated without the use of violent force, without the use of force, then they cannot be, under the law, under the Borden Supreme Court case, they cannot be used as a predicate crime of violence. And because they are not predicate crimes of violence, they did not support that murder charge and they did not support that firearms charge, which is why she dismissed those two counts. So that's why these are left standing on their own, because that murder charge and that firearms charge was dismissed because these charges, while they're not predicate crimes of violence, they're still crimes and they can still bring them against Luigi. Does that make sense? Can you scroll to the right just a teeny bit? Yes, I can. Is that better? Pierogies, is that good? These are leftover charges. I mean, yes and no, Pierogies. Allie, thank you for all those heart puffs. My goodness, thank you. So he can't face the death penalty. Nope, Lila Adams. The death penalty, as of Friday, the death penalty is officially off the table. Okay, hey Arthur, how are you? Nice to see you. Okay, Pierogies, you can see it all good. All right, so then, oh my, who sent that? Polly, thank you so much. I appreciate that. Where were we? Course of conduct. Moderate for the government. They'll have to frame the November 24th arrival, the hotel surveillance, the return on December 4th, waiting outside the hotel and using the phone as a pattern. Defense, I think, has strong leverage on this. They can argue it's a single planned homicide, not a repeated harassment pattern. The statute contemplates continuity, not just preparation followed by one violent act. So LLN, there you go. If he prepared it while he was in New York City, this would look like a very different crime, a very different charge. Thank you, pierogies. That's so pretty. I appreciate that. You guys are so kind. I appreciate you. All right. Reasonable fear, the ambush problem. Potentially vulnerable for the government. Government may argue fear can be inferred from a circumstance that confrontation plus shooting satisfies statute. I'm going to show you what I think they mean by that. Christine, thank you for that heart on my head. In just a minute when we look at the video. And again, if you are squeamish or you have triggers about watching the video of the shooting, I'll let you know and you can scroll away. Will we be able to see some pages from the notebook tonight? Yep. I got them for you. I got you, Red Gypsy. I got you. I planned this. I prepared this. What's going on with Joel? Luigi Nation, he has, I think, until the 5th to file his responsive brief. So we're not quite there yet. So are they allowed to bring up the gun and murder now that he isn't being charged with those? Yes, Lainey, because they were in the backpack at the time of his arrest, and she ruled that the backpack is in. Remember, we don't know that in the state case yet. The backpack is still up in the air in the state case, but in the federal case, the backpack and everything in it, including the journal, including the magazine, including the gun, that is all in. Love you too, Red Gypsy. All right, where were we? Reasonable fear of ambush. Major leverage pointed the victim had no awareness before the shooting. You guys been arguing this in my comments all day long. Defense can argue there was no opportunity for fear prior to death. Jury must apply an objective standard, and this is legally technical and statute driven, meaning they have to have this. It's part of the statute. This has to be proven beyond a reasonable doubt. And then the last one, see if I can get that up there. Substantial emotional distress, alternate theory. I think this is a fallback for the government. If fear is weak, the prosecution can argue surveillance itself would reasonably cause substantial emotional distress. I seem to think, how would he know he was under surveillance? Right? But defense can argue there's no evidence. Victim experienced distress prior to the shooting. The statute requires more than speculative emotional impact. Use of interstate facility. This is moderate for, I think, again, this is just my opinion. Moderate for the government, but there is some leverage that if the government cannot tie digital activity to the stalking conduct, again, another one of those things, we don't know what we don't know. So that green check mark could automatically get leveraged down to a triangle with an exclamation point, which is just my, what do you say? Those are my emojis. Were you a bit surprised she didn't suppress anything in the federal case? No, I think I think she struggled a bit with it, pierogies, but I think her, if you read her order on it, she specifically laid out in a very detailed way why she let the backpack in. She let it in because of inevitable discovery. They would have found it in an inventory search. And they, in this case, in the federal case, they also had the benefit of that federal warrant. So even if they didn't do even if they didn't do inevitable discovery, even if they didn't do an inventory search in Altoona, they would have done it in New York City because of that warrant. They actually had a warrant for it. So we'll see how that plays out in the state case because they're not going to be able to play off that warrant. I don't think so. I don't think they will because it was filed in the federal case, but we'll see. Thank you, Arthur. I appreciate that. I doubt he knew he was being watched or he would have had security. I thought I had heard, Lila, that his security was in the hotel already. But I may be misremembering. All right, where were we? Identifying the defendant as an actor. You guys are all over this one, right? Strong based on the arrest, possession of a weapon, false ID, timeline, and surveillance images. I know how you guys feel about those surveillance images. You guys know how I feel about that false ID. And the text message that was sent by the AG of Pennsylvania to the FBI for facial recognition. Didn't they have probable cause to search the second he gave a fake name? No, Lila Adams, because the backpack was out of his immediate custody and control. They took his backpack and put it on a table across the room in the McDonald's, and then there was 3 police officers between him and the backpack at the time that he was detained. Good question, though. Statute fit, is this what Congress intended? I think this is overlooked a lot in trials. What was the intent of Congress when they made this statute? And I get this every now and then, mostly on YouTube and Instagram. But was the intent for someone to stalk in this sort of situation, or was the intent more of a domestic or I don't want to say just domestic, but you guys know what I'm getting at, right? Or in more of a I don't know how else to say it, domestic type situation. So strong based on the arrest, possession of a weapon, false ID in the timeline, and the surveillance images. Limited for the defense unless they amount an identity challenge, which I know you guys really want them to do. More likely to focus on statutory interpretation rather than factual denial. Do you guys realize or understand what that means? That means the intent. I'm reading the wrong thing. Stretching it raises legal or interpretation concerns. Sorry about that. Defense can argue statute was designed for harassment. That's what I'm trying to get at, harassment. And fear-based stalking charges, not ambush killings. And stretching it raises legal interpretation concerns. Government's going to argue the statute is broad and it covers this conduct. And courts have applied 2261A in varied contexts. And then narrative cohesion for the jury. Strong emotional narrative. Timeline feels methodical and planned. And for Luigi, legal narrative can separate premeditated homicide from federal stalking statute. Defense may focus the jury on the technical elements rather than their emotional reaction. Look, you should never have an emotional reaction, and that's what you base your verdict on if you're on a jury, in my opinion, anyway. So that is. Now you guys know what goes through Tat's head when she's prepping this stuff, right? Okay, you guys want to see some journal entries. The gun was not removed from the bag on camera, only shown after alleged removal. Any thoughts? So here, Sexy Twerker, you and I talked offline about this already. Here's my thoughts. Pierogies, thank you for those finger hearts. Here is my thoughts on that. If the magazine wouldn't have been found at McDonald's, I think they would have a stronger argument for those 11 minutes that are gone from Wasser's body camera. Because no, the gun was not found at the restaurant. The gun was found at the APD, but the magazine was. Now, what does that mean? In the stalking case, the magazine, if they can match the ammo that was in there to what was used at the time of the shooting, that doesn't look good, right? The fingerprints, if they can match his fingerprints to the fingerprints on the shell casings, that doesn't look good. Although I'm not sure they have fingerprint. Again, we don't know what we don't know. What I would caution you is, it is not illegal to drink a drink and then throw the drink in the garbage. And that supposedly is where they got his DNA and his fingerprints. If they have the shooter, and we've talked about this before, if they have the shooter from the time you woke up to the time they lost him in Central Park, that's one thing. But remember, there is an eyewitness that puts the shooter at the scene all night long across the street. And they supposedly, according to their probable cause affidavit, have Luigi allegedly leaving that hostel at 5:30 a.m. So you can't be at, across the street from the hotel all night long and be leaving the hostel at 5:30 a.m. Excuse me. Losing my voice. No, Lila, I don't think so. The question was his outburst in court going to affect his case? No, I don't think it will. Laura Palmer's, I was wondering if it was actually an outburst or for him just speaking up. From the people who were actually, Jules, are you in here? The people who were actually in the courtroom, Swexy Twerker, I think you were in the courtroom. The JKON, thank you for that heart on my head. When they were actually in the courtroom and they don't think it was an outburst, he wasn't yelling, he just raised his voice. How reliable is the eyewitness? User with a bunch of numbers. Welcome in, by the way. The eyewitness was sitting in a vehicle outside the hotel, and the shooter walked right in front of him. He's the one that said that guy was there all night. Now, was he sitting in a car outside the hotel all night? I don't know. I don't know. So that's going to be a question for the jury as well. LLN, I think they're talking about the outburst where he was wearing orange and he slams into the wall. Okay, let me ask, is it the outburst at his arraignment or is it the outburst that was a couple weeks ago in court? Sexy twerker, I was there. It was not a quote-unquote outburst. It was just enough to be heard, very calmly said. Pierogies, I want to know if they got that lady with the coffee next to the shooter as a witness. I know that they were looking for her, but I have no confirmation that they found her, but I know who you're talking about. Lila, so 2 weeks ago, U.C. Sexy Twerker was there. He said it wasn't so much an outburst as him just raising his voice. And when EM6, hello, nice to see you. Thank you for that heart on my head. When Jules was in here, she said that at the time it was made that there was some movement and some directions being given to the people to exit the courtroom. So he was probably, it's possible, how's that? It's possible he was raising his voice to be heard over the clamoring. You're welcome, Laura. The arraignment was him yelling. Yes, I actually have that if you guys want to watch that. But I don't think that's going to impact. Well, he would have been Mirandized by that time. I mean, they may use that statement. Actually, no. In the federal case, there's a stipulation that the only statements that they're using is, my name is Mark Rosario. There's a stipulation that they entered into at the time, when was that? It was the case management hearing before so it would have been back in December, before Judge Garnett on New Year's Eve said, I want to see everybody in here next week. Just counting down the days so I finally meet and marry my husband. Ginger, he was walking towards the holding cell when he spoke a few weeks back. Yeah, that's what Sexy Twerker and Jules had commented on. Him yelling wasn't in court though, right? The orange in PA slammed up against the wall. He was going in at that time, Red Gypsy, they were taking him in for his arraignment in Pennsylvania. EM6, do you think his legal team advised him not to make statements out loud in the future? Probably. Probably. I think there was some frustration that day. Luigi Nation, did Joel file something? Did he file something already? It's not due till the 5th. He said something regarding double jeopardy. Yeah, he said 1 + 1 is 2. Anybody with common sense can see this is double jeopardy. 106. Okay, I don't have access to the New York docket. That might be why. Are you kidding? He already filed it today? 106 pages. That's about right. KFA's was 140. Joel's doc is out today. I'll have to go look for it. Tat, do you fully expect these cases to go to appeal? Only if he's found guilty, pierogies. All right, Ginger. Thank you, guys. I'll have to go looking for it then. I don't think the gun found in the gun used to kill BT. Why would he keep the murder weapon on him? Good point, Golden Brown. We have been told that there are ballistics in this case. True. Okay. You guys want to see the journal real quick? Oh, what happened? All right. So here's... Ooh, that's too big. A couple of journal entries I want to show you guys. So again, they didn't release the entire journal, right? So we only have bits and pieces. But I want to get your impression on these because they don't specifically... What am I doing here? They don't specifically say BT. Let's do it this way. Oh my. Come on, Tats. What are you doing? Let's do it this way. All right. This... I have to move your chat here. This is from 8/15. That said, I finally feel confident about what I will do. The details are finally coming together, and I don't feel any doubt about whether it's right/justified. I'm glad, in a way, that I've predetermined. What do you think that next one? BC? Anyone have an opinion on what that is? Procrastinated. Okay. Oh, thank you. Yeah, procrastinated because it allowed me to learn more about UHC. So there's UHC mentioned. Thank you, Lila. Thank you, Progies. Thank you, Sandollar. Yeah. I've been sitting here wondering who BC was. So UHC is mentioned. And then over here on the 22nd, which I think, Sexy Twerker, you were alluding to. 1.5 months, this investor conference is a windfall. It embodies everything wrong with our health system. And most importantly, the message becomes self-evident. So do you guys think that that meets the burden of pre-planning this? Yeah, Luigi Nation, I know. Luigi, why do you have to journal everything? Do you guys think that meets the burden? Like hey KJ Mommy, nice to see you. I really want to know what you guys think. You guys are up there, that's why I'm looking up there. Sorry. Annie, yes. Yep, Lila, you don't think it does, pierogies? I think it does. It's giving cognitive dissonance. I think it does, but it doesn't. My problem with it is it doesn't mention Brian Thompson. Now, these are 2 pages of the journal. Is he mentioned somewhere else? I don't know. But he would have to be mentioned before he left Georgia or on that bus ride to Georgia. Do you guys remember when we went through the elements? Listen, he needs to keep his thoughts on paper and then set it on fire. I hear you. The word predetermined scares me. Yep, I understand, Leather. It's not specific enough to be okay, pierogies. The timeline on the journal entry doesn't match. 1.5 months from, okay. No, it matches from 10/22 to 12/4. That's about 1.5 months. The August date, 1 month in St. I think is that San Fran or St. Louis? Crazy slow. He's got a random sleep schedule, exercise schedule. Yes, he means parasites at the Bean Counter Conference. I'm wondering if he'll try to change his handwriting stays, not him. We had handwriting samples in here the other day. I'm really bad at handwriting analysis. So when he got back to San Francisco and the date of the journal entry, the timeline doesn't match what I meant. Got it. Now I understand what you mean. Do you really write this way to yourself, or do you write this way when you know it will be read? Good question, pierogies. The thing is, again, these are only 2 pages, but I don't see Brian Thompson's name on it. Right? So if he were targeting UHC, and UHC was the victim of the case, that might be more convincing to me than if it specifically said. Even if he would have said the CEO of UHC, I think I would be more convinced. A Bean Conference, yeah. Can this be speculative since he never named the victim? I don't think it rises. I mean, we're talking about beyond a reasonable doubt. If we were talking about preponderance of the evidence or probable, this meets probable cause for me, right? The probable cause to arrest, probable cause to get a search warrant. This meets probable cause for me, but now we're talking beyond a reasonable doubt. And for me, it just doesn't with the writing of the statute. We do. Life is but a mean. We do. We can look at those if you want. Luigi alludes to a healthcare bigwig, but is kind of vague about the person, right? He mentioned social engineering. Couldn't that be following BT? It could be, Annie, but BT is not specifically mentioned. The investor conference is mentioned. So how are they supposed to prove that BT and not one of the other investors were put in fear of bodily harm because of this? You're not completely convinced, Luigi Nation? Yeah. So this, to me, is just problematic enough, in my opinion, in front of a jury. It's just problematic enough. Meaning it could go either way, depending on what the jurors think, depending on the rest of the evidence, which we haven't seen yet, right? So if this is combined with like an email to Brian Thompson, a text message to Brian Thompson, even an email to the CEO of U.S.C., that would be problematic for me. That would probably push me over to beyond a reasonable doubt. But I haven't seen everything yet, so I'm keeping my mind open, and I would encourage all of you to as well. Hello, St. Luigi of Maryland. How are you? Are you saying that he would have shot any of the bigwigs, so this would apply? Annie, what I'm saying is, in the indictment, they specifically named Brian Thompson as his target, and this doesn't have Brian Thompson's name in it. That's what I'm saying. But we don't know if he targeted him some other way. Is this? No, this is not the journal. That's just a letter from him. All right. Now that we read that, here's what I want you guys to see next. Now remember, the big thing is, any other questions before we go on to reasonable fear? That's what I want to cover next. And I'm going to push you guys on this one. Just so you know, I'm going to push you on this one. And I am going to show, wow, Andrea, thank you so much for those gifts. I appreciate, holy crap, who did that? Pierogies. Thank you so much. I appreciate that. Why would a person carry notes on them if they were intentionally going to carry through with anything? Good question, Karen Lynn. I will say I work in a farm, and after this happened, shit went south. Trying to feel anything to UHC. Thank you, Pierogies. I appreciate you. I am going to show this shooting, so if you are sensitive to that, please scroll out. You can come back in like 5 minutes. I've been teaching for 29 years. I don't remember anyone writing in their lowercase like Luigi does. I don't know of anybody his age that writes. Do you know what I'm saying? Like, they all have electronic journals. Pierogies, no, literally, why did he journal? Luigi is way too smart to be carrying all of this. Dakota, do I think Luigi is mentally ill? That is a very broad diagnosis. And first of all, I'm not a mental health person, nor am I a medical doctor. I think he probably, I don't know. I'm just going to say I don't know, because it's not fair of me to put that label on somebody when I'm not qualified to give that kind of diagnosis. Was he still suffering from brain fog? Is that why he wrote everything down? It could be, Gemini. Should have put those in the ocean the day of Lila. EM6, a lowercase e is what I'm saying, is very unique. I see what you're saying, yeah. With the straight across. I really think he was struggling with something. Pierogies, allegedly he was struggling with his back surgery, the results of his back surgery. Luigi is not street smart, golden brown. User with a bunch of numbers is the, oh, thank you, Andrea. Are you going to sleep? I don't blame you. It's after 9. User with a bunch of numbers. Is the logging of the letters he receives intentional to refute the journal entries and deny them? You would have to ask him, user with a bunch of numbers. I've never seen logs like that before, but do we know if he's left-handed? Cherokee, he is left-handed, and I think somebody told me he's actually ambidextrous. He's left-handed, but he was encouraged to use his right hand growing up. And the reason I know that is my dad was left-handed. My grandmother thought that was a disability and forced him to use his right hand instead. As a result, his handwriting is atrocious. My dad's hand, I can't read anything my dad says. Wait, he logs the letters he gets? He does. He's been writing in court with his right hand. Interesting. Like in jail. Yeah, Lila. Cherokee saying that tracks with the terrible handwriting. Yeah. I agree. Isolating yourself from everyone you know for months isn't typical. Yeah, like I said, I don't have a degree that I would feel comfortable with putting that tag on anybody. Is there any chance it's not really his journal? Always. Life is but a meme. Maybe the handwriting is one in the left hand, one in the right. Gemini, that's possible. I never thought of that. My stepmom has a large handwriting, and she's left-handed. I'm trying to think. I don't think I know anybody offhand that's left-handed. I used to work for an attorney who was left-handed, and his signature was so beautiful. There's no other way to say it. It was so just like, it looked like typed font. But he used his left hand. All right, we're going to watch Taya. Thank you. Oh, Taya, hello. Nice to see you. Thank you for that paper crane. And Andrea, thank you for those donuts. My dad and brother, I can't read anything they write. Yeah. I don't know. I haven't read my brother's handwriting in a long time. If BT is not all mentioned in the journals, what's left for the prosecution? Data. Data. Holy crap, Allie. Thank you so much. Oh, that was cute. I appreciate that. Thank you. Marky, thank you for that heart on my head. Yeah, sexy twerker is going to be data. So whatever in that MacBook, whatever in that cell phone. Can't believe Luigi's getting away with it. He hasn't yet, supply chain fixer. He hasn't yet. Lainey, I'm a lefty and my printing is very neat. You guys, oh, thank you, Progies. I appreciate that. You lefties are so more creative, I think. That's why your handwriting is so flowy. By getting away with it, I mean getting away with not doing his crime we all know he didn't do. Not yet. Not yet. All right, so I am going, where can I view these journal entries? Violetta Mezzanotte, if you email me, I'll send them to you. You're a lefty, sexy twerker. Okay, so I know a lefty. Yeah, anything that I show up here and you guys want a copy of, I do not gatekeep. So if you want it, just email me and say what you want. And then when I go through my emails, I'll just send it. So I am about to show the actual crime. So if that upsets you, please scroll out now. But I want you guys to watch. We're going to watch the first 10 seconds of this. And I want you guys to keep in mind reasonable fear of being killed or hurt. Right? We're going to watch the first 10 seconds. Are you guys ready? Okay, that skipped. Hang on. All right, who knows what I'm going to say? Yeah, St. Luigi of Maryland. When I get a copy of it, I will absolutely break it down for you. Yeah, absolutely, Taya. Oh, there's no need for me to gatekeep. Cherokee, have they ever determined how he would have known who that was? No. Between the first and second shot, life is but a mean. You got it. Yep, that's what I'm thinking. Move it down a little. Yep, absolutely. Is that better? You was going to say that wasn't Luigi. No, that's not what I'm saying. I'm saying that we don't see a face, so I don't know who that is. Doesn't seem overly scared. No gestures. Okay, I'm going to play this again. And I'm going to pause it at a specific place. Let me see if I can get it. Right there. At that point, do you think he's in reasonable fear for his life? Definitely not your man, my six diamonds. How are you? It's nice to see you. I haven't seen you in a while. Lainey says yes. So the first shot hit him in the calf. Hey, Black Mug. Nice to see you. No, absolutely. Unfortunately. Man down, man down. Nope. Okay. All right, sexy twerker. Hold on to that. I'm going to push you with this. I told you. I think he didn't even know what was happening. I agree with that at this point, Pierogies. Do you have an update on what's going on with him on your page? I do, yeah. And apparently Joel filed something today that I got to go grab, and I'll break it down for you guys. Don't worry. More confused? Okay. All right. I'm going to play a little more. And it's going to skip, isn't it? All right. So here's the thing. We stopped it here. How about here? You guys think he's in fear? So after the leg shot, how he hit the head. Thinking the second shot is what scared him. I think the first was shocked. He may have heard the witness scream, which possibly would have induced fear along with the bullet. Good one, Bree. That's good. That's a good analysis. He probably thought he had an insane Charlie horse. Pierogies. You're trying, Pierogies. I'll say, you're trying. He was confused. He looks to see what's happening. Yeah, he turned around. So here he's facing the shooter. He's in fear of being shot. Yeah, I know, sexy twerker. Me too. He didn't see it coming. If he was, why not go inside? Lainey, he got shot in the leg first. I know, Progies, you are trying. You are trying, but that's not stalking. Okay. Okay, Violetta, yeah, I'm going to get to that. I'm going to get to that. Till he was hit the first time and turned around, saw it again. I don't think he was scared. Okay. I'm going to play a little bit more. That's the first shot. And he was hit in the leg. Okay? That's the second shot that jammed. So that shot did not go anywhere. Shooter is clearing that. That's the third shot while he's laying on the ground. Now, do you think he's in fear? Mark A., we're answering whether or not Brian Thompson was in fear for his life. No. Yep. Yeah, there's no, I don't have a shot of the face. Yes, yes, no, yes. Luigi doesn't walk like that. We're not analyzing that right now, St. Luigi of Maryland. But I know, we went through that. Remember, we went through that. Facing him, he probably has fear. Laying on the ground, I think he has fear. He's stunned and confused, yeah. If you've passed away, can you be afraid? He's not passed away yet because he's just about to get that third shot off. Because at the part where he's laying down, he isn't even looking. He might be scaredish, yeah. Banana milk, no, you don't have to stop. Likely confused. Allie, do you think he shot him in the leg first on purpose? No, I don't. No, I don't. All right, so just for continuity, I'm going to play this one more time. I'm going to take it down just in case there's people out there who's sensitive. But I do want to show you where the shooter walked for somebody who was asking me about the eyewitness and show you where the eyewitness was. Okay, you're going to see the shooter go to the left. See those car lights that just blinked? That's where that eyewitness was that said the shooter was across the street all night. Young lady, if a person is guilty of taking a life, why does the true justice take so long? Monroe Smith, because the wheels of justice, they turn very, very slowly in our system. There's a car there with the taillights on. That is the witness that I think I have his statement. Might have been in too much pain to be afraid. Oh, pierogies, I don't think so. If you get shot in the leg, I think you're in enough pain. Don't get me wrong. Hey, Jules. But I don't think it's too much. How do we speak to BT's mental state? Audio would help. Good point. Again, we're talking reasonable person, sexy twerker, right? Reasonable person. If you get shot in the leg and you turn around, you see somebody holding a weapon pointed at you, are you going to be in fear for your life? I don't know what they're going to argue, sexy twerker. We're going to have to see what the motions in limine say. There was only 3 shots. So Brett, there were 3 rounds, I guess I should say. There were 2 shots. He shot once and hit him in the leg. The second shot jammed. He cleared that. That was dropped intact on the sidewalk. Then he walked up to him and shot him again. But it's not stalking. Okay. So does this make you, Violetta Mezzanotte, think that this is more of a premeditated homicide instead of stalking? Okay, Polly. Yep. I will ping you. That's what I think, St. Luigi of Maryland. What did the bullets delay, deny, depose? Not the bullets, the casings. Remember, there's 2 parts to a bullet. The bullet is the inside that gets shot out, and the casing is the outside that gets dropped out of the gun. You don't think it's stalking, Lila? Okay. Premeditated, yes. But he's not charged with premeditated murder, right? He's charged with stalking. So I think by the time he hit the ground, saw the gunman, had the time to register, scream over, witness, fear present. Okay, Taya. Also, no face, no case. I hear you, sexy twerker. We're not talking about that tonight. All right, so here's my thing. It's really going to come down to what data they have. Between the journal and what data they have, that's what it's gonna come down to for me on this. So I'm keeping my mind open, and I would encourage all of you to do the same until we see what NYPD has. So how many years is he looking at now? If he is convicted of stalking that ends in death, that is life without parole. Do you have to have stalking to be premeditated? No. No, that's two different crimes. What makes them want stalking over premeditated? Crime Bear, they had a murder charge. They actually had a capital murder charge that was dropped by the court because they did not have a predicate crime of violence. And that is necessary for a federal murder case. There we go. All right. Questions, comments, criticisms. Thank you, Violetta. Thank you, KO. It's nice to see you. What's the definition of stalking? Mark A, we went through that at the very beginning. I'm going to post this over on YouTube, and you can go through it all with me. But it was like the first 20 minutes we went through each element of the crime that they need to prove beyond a reasonable doubt. Is the reasonable fear up to the incident, or can it include occurring during this? So the reasonable fear has to be as a result of the planning and the continuity. Damn, why can't I remember these? Course of conduct. Thank you. So the reasonable fear has to be a result of the course of conduct. She is, Taya. She's amazing. Thank you, Black Monk. I appreciate that. Shooting. All right, am I back? That's because I was showing the shooting. That was fair. That's fair. Going back to the earlier discussion, Brian Thompson is showing as a specific target because we'll have to wait Brady B and find out if he is listed somewhere in the data. Yikes, first 20 minutes it seemed like Lou could get off easily, but afterward, yeah, Violetta Mezzanate. Yep. You think it happened too fast for him to have fear? Taya, thank you for that follow. He was the only one they're preparing to speak to the rest of the U.S.C. attendees. You can ask me something, Brittany. Absolutely. Sorry, when did the suspect go? Where did the suspect go after the previous frame? We saw it to the left through an alley. I did, Lila, most likely because I showed that video. Hopefully I'm back. He would have been crazy to get pew-pewed, turn around to the pewer and not be afraid. I agree. I would have been afraid. Where's the harassment? It had to be harassment. No, it had to be, hang on. It has to be reasonable fear of death or serious bodily injury or caused or would reasonably be expected to cause substantial emotional distress. The stalking charge really confuses me. It's a lot of moving parts, pierogies. It's a lot of moving parts. If someone is coming out of town for trial, should they plan June 8th or hold? Wow, Jules, that's a good question. You're welcome, Brett. How rude of them. I don't know, Jules. At this point, I don't know. Concealed files be because they are hiding stuff from me, even if it's your own case. Are you charged or are you the victim? It only takes seconds to experience fear. Good point. Lila, I would have been afraid, but I think it was too quick even though it jammed as fast. I think he probably wasn't, he probably didn't comprehend everything in those 2 seconds, but I think I still would have been afraid. So 100% Luigi that did the shooting. No. Most Sweets, no. Doesn't walk like him. Starbucks doesn't look like him. No, I didn't say that. I said I'm reserving my judgment. How long do I see it lasting? Probably about 3 to 6 weeks. Considering what happened with the suppression hearing lasting 3 weeks, I would say closer to 6. But fear before the act, no, not during. It has to be as a result of that course of conduct that the defendant engaged in. Violetta, does that make sense? They have to have fear as a result of the course of conduct. And it cannot be one thing. It cannot be one explosive act. I think he was only afraid after he turned and saw the gun, but that's just me. So here's my question, Violetta. It cannot be because of one act. So after the first shot, when he turns around and he sees the shooter pointing a weapon at him, and he has already been shot in the leg, and then the shooter is walking towards him, is that enough to satisfy the stalking statute? Because the first shot, right, it can't just be this first shot, but he's walking towards him and he continues to shoot. Is that enough? I told you I was going to push you guys on this. I think he was only afraid, but that's after he turned and saw the gun. Most sweets, no face, and conflicting info on shooters timeline. Boy, sexy twerker, are you just holding on to that like a dog with a bone? I hear what you're saying, though. What will happen if he comes out of prison? He'll go to New York State because they have a detainer on him. And then when he gets done with New York State, he'll go to Pennsylvania because they have another detainer. And if he magically gets out of all 3 cases with not guilty verdicts, I'll just say if I were him, I'd leave the country. Can they say you're a missing person under a different name with a picture? Brittany, I would definitely need more context on what you're asking me on that. Sorry, I missed the beginning. Shouldn't have been on a pattern. Yes, it has to be a pattern of behavior, and it cannot just be one singular event. So is it fear at any time of the act? It has to be fear as a result of the pattern of behavior, of the course of conduct of the defendant. Why leave the country, Ryan? I just think that there's enough people here that don't like him. If it were me, I would leave the country. Plus, I think somebody said he has a dual citizenship with Italy. Any reason to go live in Italy, I'm down with that. So stalking can occur over the course of 20 seconds. That's what I'm asking you. That's what I'm asking you, Life is But a Mean. Is that enough? We just went through all the stalking, right? The elements of the crime. So it's not even 20 seconds. That whole thing that I showed you was 10 seconds. It's probably more like 4 seconds. Is 4 seconds enough to satisfy the elements of the crime of stalking? But thank you for getting me there. I appreciate it. Does it have to meet all the elements of stalking statute? Yes. Yes. No fear, the charges fail. Yep. Is that one moment enough to fulfill stalking statute? Look, Taya, you're like in my brain. I love it. Enough to fulfill stalking statute. I think there's a strong argument against it. I do too, but I also think that there's a strong argument for it. And I don't think it's fair and I don't think it's lawful, but I think that it's inherently biased as us as human beings, and that is the emotional aspect of it. When they see that video, when they show the jury that video, it's going to be really hard not to have sympathy for Brian Thompson at that moment. Does that make sense? It was too fast, I think, for him to realize what was happening. Selena, he didn't have to realize what was happening. He just had to feel fear. He had to feel fear. Wouldn't the entire shooting be one continuous act? That's a good argument there, Beth Fullerton. That's a very good argument. I only see the one act, Mark A, the same way. Happy to have Luigi here in Australia. I believe he does have dual. Yeah, I think he does too. Hello, Denise. How are you? Happy to, let's see. Not in my book, even though Brian Thompson was scared. Okay. Caro is probably on U.S.C. payroll. All right, we're dealing with fact in here, St. Luigi. Hi, any recent updates? Love Life, we just went through the stalking statutes element by element of what they need to prove beyond a reasonable doubt. Apparently apparently Joel has issued his post-suppression brief, and I'm going to have to go pull that and break it down. I'll have content for you on it tomorrow, but it's going to take me, apparently it's 109 pages. It's going to take me a while tonight to break it down. You need to know my opinion, Allie. I'm open until I see what data they have. That's not stalking to me. I don't think it would be for a jury either. The journal is damning, but as somebody brought up earlier, the last journal entry that we know of is a month and a half before the crime occurred. I want to see more journal entries closer to the crime, and then I want to see any data that they have. Hey, Whiskey, how are you? Thank you for that heart on my head. Seems like stalking charges will fail. Sexy twerker. I just love your optimism, my friend. I wonder how his legal team is holding with the state trial coming so soon. Pierogies, I can imagine that it's like running around with your hair on fire. You don't think it's stalking, Lainey? Unless they can prove the shooter was Luigi. Well, that's the other thing. Life is but a meme. I'm sure that they have, and I've said this on here before, that they have the shooter on surveillance camera in Manhattan from the time he took a shit in the morning to the time they lost him in Central Park. So we're just going to have to wait and see what NYPD has. Isn't the entire shooting one continuous act? Beth Fullerton, that is a question I'm asking you. Is it one continuous act? Or was there enough of a pause between shot 1, shot 2 that jammed, and shot 3? I also want to see the COD, personally. Which I believe COD is going to be shot 3. Because that's going to be important for that enhanced penalty, right? Yeah, but you cannot see the shooter's face. I get it, St. Luigi. I get it. They don't like Luigi, but Brian is a bad man and a crook with his stock market automatic denial. Oh, thank you, Whiskey. Appreciate that. Thank you for those hearts. Why did they pick that charge instead of premeditated? That would have been an easier win. Mark A, these are federal charges, so in order to get a federal murder charge, you have to have a predicate crime of violence. And to get a predicate crime of violence, that is necessary for the capital murder charge, right? Or for the capital penalty, the death penalty, which I believe is what they wanted the whole time. All right, you guys, I'm resetting the chat, so if I didn't get to your question, just ask it again. Pause with no mercy. Yep. I think it's one continuous act. Okay, Beth, there you go. See, now you're a juror. Now you know that you just made a decision based on a jury. I want to see a specific mention of BT in the notebook. Yeah, Pierogies. I want to see that or in data. If he sent him an email, sent him a text message, I want to see specifically that it was Brian Thompson, because remember, in the indictment, it says Brian Thompson. So I want to see that it was actually Brian Thompson. Could COD be lack of anyone helping? User with a bunch of numbers. I like how you think. Yeah, nobody went over to him for a very long time. It was the first, not even the first officer that appeared. It was the officer that came from the opposite direction that ran over to him and started giving CPR. So we're looking at like 4, 5, 6 minutes of him being down. Oh, my opinion on fear, I think he felt fear between those 2 bullets. Absolutely. I think he felt fear. Hey, that guy, Alan. Nice to see you. Jury nullification. I hear you, Violetta. You can't say that in court, though. You realize that, right? Shot plus C shoot plus crawl away equals fear. I think so. Nobody helped him, Lainey. No. I would really like to see the COD and the TOD. St. Luigi of Maryland. You are brutal in here tonight. If they can't crack Luigi's tech, what happens with it? Then they can't use it. Real life is in Criminal Minds. It's not all going to be wrapped up in a bow. Excellent analysis, Denise. Yes, this will not be finished in 48 minutes with commercial breaks. But isn't it still speculation that he felt fear? Absolutely, life is but a meme. But remember, we're using the reasonable person doctrine, or the reasonable person definition. Would a reasonable person in that same situation feel fear? People denied help. I know, Violetta. We're not arguing that here tonight. Hey, Super P. Nice to see you. They can't bring up that he was correct. I doubt it. No, that's way too inflammatory, Beth. 676. Is that Luigi? That is Luigi. And his attorney, Karen Friedman Agnifilo. Look, I can say it now. I'm so excited. You got it? Okay, good. I am hoping that I didn't confuse you more than I educated you tonight. I was not intending to confuse you. But now you see why it takes so long to put these cases together, right? Interesting that the officers didn't assist, but New York officers have no obligation to render aid. You're right, Taya. Have you seen the whole video? Because it wasn't just the officers not assisting, it was his fellow investors and CEOs who were there that didn't assist. They just looked at him. Nobody went over there to even sit with them. There were 2 of them there. And tell him to put on the glove. If it does not fit, yep. If Super P, if he wasn't there, he was sleeping on your couch having beers. Yeah, Taya, I guess you haven't seen. I'll send you the whole I'll send you the whole video. It's disturbing. There's no other way to say it. Like, people just walk by, look at them, and there's a lot of nuance. The paramedics didn't do much either. Well, I'm guessing by the time the paramedics got there, life is but a meme, and all they could do is load them and take them. Let's watch all the video. Do you guys want to watch all the video? Yeah, Tay, I'll send it to you. No problem. Cannot find a version as clear and unedited shooting. Where unclear version on X. Regipsy, just email me and I'll send it to you. Can you give us an idea how skilled lawyer refutes stalking versus moments of shooting? It's going to be that reasonable person definition. They're just going to argue it. Garnett follows the letter of the law. Woo, that went fast. Hang on. So I'm hopeful restalking charges failing. I know, optimism. No, I hear you. I think she's been really fair. I think she's been very fair. And look, her writing is almost as good as KFA's writing. When you read her orders, she's very specific. And she's very good at putting out or pointing out exactly why she's ruling on what she's ruling on. I'm not going to contrast her to Caro, but maybe that's why he's in state court and not in federal court. There, I said it. How do people do that? I could never just walk by someone. I hear you. Third shot, looked at him in the eye and pulled the trigger. How do you know that, Denise? We couldn't even see his face. Makes you wonder if there was a conspiracy to get rid of him. Laney, he was supposed to testify the next month in Congress regarding those insider trading accusations. Luigi and me at the VIP, Bad Bunny wrote a song about it. Super P, you're tripping me out. Okay. Hey, St. Luigi, we are nice in here. Remember, everybody's allowed to have their own opinion. And Denise has always been very, very cordial with her opposing opinions. So I just ask that everybody has the same respect. Hello, how do I find your email in your profile? Yeah, absolutely, Andrea. There's a link on my link tree that says send a case or a question to Tats. Just send that. Or my email is tatsandgin@gmail.com. Julianne, we went through what's left in his federal case. We went through all the elements of the crime and what they need to do to prove it beyond a reasonable doubt. Learn more here in 40 minutes than in 40 hours of CNN coverage. Thank you, Taya. I will take that as a huge compliment. I appreciate that. That's okay. Everybody's allowed to have a slip-up, St. Luigi. It's all right. Do you guys want to watch the whole thing? I will show you the whole thing once. We'll play it through just once. Did I already close it out? That's all right. For you guys, I will pull it back up. Please get him home. I have no control over that, Julianne. I'm just reporting in 40 years of CNN coverage. Don't get your news from mainstream media. Is that not what Bad Bunny said? I don't know. The whole time I thought you were... Okay, I'm going to pull it up. You saw it in court 100 times. Sexy twerker, I imagine. I can only imagine. And look, listen, at the trial, they're going to play this as many times as they can get away with. I'm going to tell you that right now. They're going to play this as many times as they can get away with. Hold on, I'll start it again because I think it was... All right, can everyone see it? Is it down far enough? Are we good? What are charges drops? Francesco. They dropped the murder charge and the firearms charge last month. Can everyone see this? Just give me a thumbs up. Down a little. Okay, hang on. Is that good? Yeah. Yep. Sexy twerker, absolutely. Good. We're all good. Okay. Yeah, sexy twerker. Joel's going to play this. Hey, Jeremy. Big hugs right back to you, my friend. He's going to play this as many times as he can. A little bit more writing is on it. How's that? Is that better? All right. Here we go. One time through, you guys. Sorry, Lila. What just happened there? Oh, Sorry, this is not the edited version. Sorry, I pulled the wrong version. Let me bring it back. I lied. We're going to watch it twice. Okay, ready? Love life. I think it's going to depend on the outcome of that suppression hearing, whether or not the state will be harder. Pierogies, it'll be okay. It'll be okay. I've played this before. It did, St. Luigi, on the second try. Who's allowed in the courtroom during trial? Anybody. Yep. Rando's like, you can show up. Yep, life is but a meme. I would never judge you for just showing up. I love watching trials. Sweet Pea, thank you for those gifts. I appreciate it. What's the evidence against Mangione? Backpack filled with the weapon, a magazine, writings, travel documents, and notes. Caro defers to the prosecution. How many times did he shoot? Technically 3. The first shot came out. The second shot jammed. He cleared that, then walked up on him and shot him a third time. But only 2 shots hit Brian Thompson. Now you see people walking up to him and then walk away from him. No one tends to him. We're a minute after the shooting. Jesus, so there's a gag order in this case, so the forensic evidence that they have has not been released to the public. And if you look straight down there, Taya, are you still in here? Straight down there, you see 2 of the investors from the conference that are just standing there staring at him. Is Taya still in here? Yep. They're about to walk up on him, and they just walk past him. Nope, not one person. You're going to see a cop car come from the opposite direction. That police officer is going to come out and start. That police officer is going to come out and start CPR. So men just look, yeah, Francesco. Taz, this surprises you more than someone cold-blooded shooting someone. What do you mean surprises me, Denise? It surprises me that they just walk by and don't help him. That does surprise me. I mean, can we be a little human here? It's wild how no one helps. Yeah, to be fair, passed out people on the street in New York City is commonplace. But you have 2 people come out and say what just happened, right? Defense should use the death caused by failure to assist. I want to see the COD and the TOD for sure. Yeah, the blue guy in the guy in the blue jacket is the one who said that the shooter was on the corner the whole night. Women would have tried to help. The shooter is fine. We don't know about ballistics yet because of that gag order. Bright 6 diamonds covering the bleeding and the wounds, yeah. Person who does CPR stops to look for the ambulance. Who's the guy that saw him all night? It's the guy who got out of the car where the lights... Remember we pointed out the car that the lights flashed? It's him. The driver of that car. So now he's getting aid, so it is 3 minutes. Just over 3 minutes. Yeah. Yeah, Taya. They walk past him over and over again. And now he's finally getting aid. Someone's got him. Tracy, this is the shooting of Brian Thompson. December of 2024 in Manhattan. Somebody walking into the crime scene. I missed it, but at one point you can see one of the guys in the suits go over and pick up one of the shell casings. I don't know if I really damn him for that, simply because it wasn't, cordoned off yet. Beth Fullerton, yeah, it doesn't take long if you're shot in the right place. There's something Machiavellian afoot. Most bizarre video, no help, scene disturbed. Yeah. You would think they would have people, you know, at least securing the scene. But again, it's only been 3 minutes in. And you know, and look, this guy just left. That blew my mind the first time I saw it. That guy just, I'm out. You know, peace out. I just saw someone get murdered, but peace out. Hey, Stefan Carmichael, how are you? How are you? I hear you, St. Luigi. I hear you. I still don't see them doing CPR yet. Are they over there? Not. I think the one officer was over there tending to him, and then the ambulance, I think, is just pulled up, and that's when I think CPR starts. You see him on the ground. Hotel was staffed with security. Yeah, this is the Hilton. Krista, that wasn't, that's not everything that needs to be in the stalking charge. Again, we went through that, the first part of tonight's live. Thank you, Stefan. I appreciate that. But this will be over on YouTube probably tomorrow when I edit it and get it over there. Yeah, Lila, I agree. I agree on both parts. It's not, I don't condone murder, and he is a fucking human. Go check on him. I agree. Okay, Kristen, I have been told that he had security who was in the hotel already. Yeah. Of course, Caitlin, it is New York City, right? New York City, they just kind of walk past everything. Thank you, Krista. I appreciate that. J.E., what happened? I wasn't here. Someone give me a summary. Oh, I haven't even seen it yet, J.E. I didn't know it was out there. I had a meeting right before the live. I hadn't had a chance to look for it, but I'll go get it. I'll digest it tonight, and then I'll get you guys some content on it tomorrow. Yes, he is, Stefan, but that case is on hold. The Pennsylvania case is on hold until New York is done. Oh, Violetta, I meant no disrespect. I'm sure true New Yorkers do help. Regardless of the reasons for doing what he did, multiple people just stood and stared. It's disgusting. I agreed. Do you go to the court dates yourself? I have not yet, Ariana, but I plan to go to the trial. Both trials, if I can. Mark A., if you see somebody with a suit and tie, I'm sure you see red stuff. It's not a drunk. Yep. So that is the entire, video as I have it. I'm pretty sure that NYPD has more than that. Yeah. He's a bullseye. I got to meet him in Harrisburg. Oh, you got to meet Thomas Dickey. Oh, I saw him. I saw his press conference. And the way he talks, he sounds like all of my great uncles. Sexy twerker, I kind of want to see the COD and the TOD. Yeah. Also, not for nothing, he is a human and had a family regardless of financial status as well. Yep. How can they have a federal case plus 2 state cases for the same crime? Good question, Arena. So we have dual sovereignty in our country. So we have sovereignty at the federal level and sovereignty at the state level. Each sovereign has their own criminal crimes or criminal statutes, which means that you can violate federal statutes and state statutes in the same action. And that is what happened in New York. So New York brought murder charges, but so did the federal government because they brought these interstate stalking charges as predicate crimes of violence and then brought a murder charge and a firearms charge. The murder charge and the firearms charge was dismissed because the judge said that the stalking charges did not meet predicate crimes of violence. So now in the federal case, he only has the stalking charges, 2 of them. In Pennsylvania, he's charged with a firearms offense, forgery offense, and tampering with evidence offense. And that is because he was found in Pennsylvania with a weapon and a false ID. That's how he got all 3 cases. I don't know if he did it or not. I hope if innocent goes free. Got it. Stefan, I missed some of the past weeks. Have they made a decision on the search of the bag? They did in the federal court. The bag is in. We're still waiting to hear on the state court. Every New Yorker I met was super nice and helpful to me. Yeah, me too, Beth Fullerton. I was just there in January, and they were super nice. The taxi drivers are really nice. I think I told that story in here about my daughter and her husband and I in the taxi, and the taxi driver telling them the story of his experience on 9/11 which all of them, it was my daughter, her husband, and their best friend they were alive in 2001, but didn't have independent recollection of it. And it was really interesting to watch them react through, a different lens. You're welcome, Stefan. Lila, again, working in pharmacy, I understand insurance on a technical standing doesn't make it okay. Yep, I hear you. We are the best. Hey, NYC for LNM. Nice to see you as well. All right, I'm going to take I told you guys 5 minutes about 20 minutes ago. So I am going to take last questions. In the end, no one should take the life of someone else because they're angry about a societal issue. EM6, I totally agree. I do not believe in vigilante justice, as you guys know, but I also believe in the Constitution and the rule of law. So anybody in that defense chair, whether or not you consider them a monster or not, deserves the same constitutional rights as everybody else in our country. I was there on 9/11, had to walk from Manhattan to Brooklyn. Oh, gosh, most streets. Yeah, he was working as a photographer in, not in Times Square, but off of Times Square, and he had to run for it. You're welcome, Stefan. Good night to you as well. Francesca, thank you for that follow. New Jersey lady, yeah, I'd agree. Yeah, he does. NYC for yelling at him. He deserves a fair trial just like everybody else. And I want to remind you guys, and I tell you guys this all the time, but it's worth repeating. For every Luigi Mangione you see, for every Karen Reed that you see, for every Harvey Weinstein, Nick Reiner, all of those cases that you see, remember that there are hundreds, if not thousands of others out there who don't have high-powered lawyers, who don't have $1.4 million gift and go accounts, and still have to represent themselves or find, counsel to represent them in the same situations that all of these high profile cases are. So remember, it could be you. You could be in the wrong place at the wrong time, and all of a sudden your butt's in that defense chair. So if you're not going to, if you want somebody to fight for your constitutional rights, it's important that we evenly distribute the rights of constitutional rights across our nation. And that means you don't have to like who's in that chair, but you've got to make sure that their constitutional rights are protected. Hey, Kevin, nice to see you. Thank you for that heart on my head. Andrea, thank you for being title gifter of those roses. All right, you guys, I am losing my voice. The series accused, it is. Yeah, that's a good one. Are you an officer of the court? No, I am a paralegal. What's the point of this vigilante? Your comment went too fast. Is there a way for Caro to still revoke his decision for state trial to go first? Yes, there's always time to do the right thing. That's how I know it's time for me to get off here. I'm getting punchy. You're welcome, Golden Hilliard. Thank you for being here. What is the point? Why are you spamming my chat? Are you an officer of the court? What is the point of this live? Vigilanteism? No, the point of this live is to be educational and entertainment purposes only. I don't know who did that, but thank you. You're welcome. Yeah, Kelly Koch, I appreciate you guys being there. Oh, thank you, Sexy Twerker. Appreciate that. I appreciate that, Brett. All right, I will go grab that filing from, what's his name today, Joel? And I'll digest it tonight because, I don't sleep anyway. Thank you guys for being here, and hopefully I at least educated you or unconfused you a little bit on what's going on in the federal case. Thank you for the 69,000 tabs. Thank you for all of the gifts you guys went overboard tonight. I appreciate that. You're welcome, Taya. Oh, thank you for being here, Taya. I appreciate it. Yeah, absolutely, Sexy Twerker. It's absolutely my pleasure. I really do enjoy teaching, and you guys give me that outlet when I'm not teaching. Yep, tomorrow, Einlass, it'll be on YouTube. Give me about 24 hours. Jules, thank you for those roses and those flowers. I appreciate it. All the gifts tonight, you guys. Thank you. Who did the paper crane? Oh, it goes too fast. Hang on. Whoever did the paper crane, thank you. Those are beautiful. Oh, Taya, you sent another one? Thank you. I appreciate that. When am I live again? Probably tomorrow night. Well, yeah, tomorrow night, because if Joel has that thing out, then we'll go through Joel's pleading tomorrow night. You're welcome, St. Luigi. You're welcome, Beth. You're welcome, John Boy. All right, so I'm going to go grab that pleading from Joel. I'll digest it tonight. I'll get you content tomorrow, and then we'll go live on it tomorrow night, okay? We'll see what Joel has to say. Thank you, Red Gypsy. Appreciate it. So be good to yourselves. Be good to those around you. Make good choices. I will see you tomorrow night. Tats out.